We brought you from day one. A judge has now dismissed racial discrimination claim in this case, dealing with a black child in the school system because he had the audacity to have braids. Let's put it up full mass. This is about conformity. This is about violation of the Crown Act as I see it and many others across this nation. A federal judge on Tuesday dismissed claims of racial discrimination while allowing, however, claims of sex discrimination to proceed. I will explain this. This is a federal civil rights lawsuit regarding a Texas student who has faced multiple suspensions, multiple actions against him, disciplinary actions, over the length of his hairstyle, his locks, all right? The ruling comes months after a separate federal judge ruled the state's Crown Act, a law that prohibits discrimination against hair texture and protective hairstyles like locks and braids that are, quote, commonly or historically associated with race, does not make it unlawful for school dress codes to limit a student's hair length, meaning it did not violate state law for the district to continue punishing George for the length of his locks hairstyle. U.S. District Court Judge Jeffrey Vincent Brown said in his decision that the claims of racial discrimination in a lawsuit brought by Darryl George, a student at Barbers Hill High School, and his family, quote, have not shown a persistent widespread practice of disparate race-based enforcement of the hair policy, which, by the way, is not required under the statute. Brown said, at most, the plaintiffs allege on 2 instances. The allegations underlying George's case and those underlying the Arnold case, also pending in this court, Brown said, referencing another case of a black teen who was suspended over his hair. But these 2 instances alone are insufficient to establish a pattern of conduct going on for so long or so frequently that it evinces a persistent, widespread practice. Regarding the claims of sex discrimination, Judge Brown said, while the school district gives reasons that show why they have a dress code, quote, they provide no support for the narrow question that forms the basis of this claim. What is rational for the dress code's distinction between male and female students? Because the district does not provide any reason for the sex-based distinctions in its dress code, the claim survives this initial stage. Brown said the judge dismissed all of the family's other claims, including infringement of Georgia's First Amendment free expression rights and request for compensatory damages and injunctive and declaratory relief for claims of mental anguish. I'm going to get into a little bit more of this and then provide some context for the leadership of this madness. The student simply has a hairstyle that's uncommon for white students to have. And so he's discriminated against by wearing it. He's suspended. They say you got to cut your hair. You can't wear it this way, obviously in violation of the Crown Act. Now, what the judge has really done is dismiss all charges. He's dismissed all claims. All claims. I know it says he only dismissed this one, but he kept that one intact. He really didn't. He really did not. The school failed to provide a reason for why they will allow hairstyles or lengths with female students to be longer than male students. And so what the judge did, because the judge already knew, he's stretching it with saying, because there's no persistent, ongoing, historical violation, it does not fall within a violation of the Crown Act. Now remember, the judge didn't say there's no discrimination. The judge did not say there's no inequality. He didn't. He decided to go to what is seemingly the letter of the law. But the lawmakers who made the law, the legislators, which by the way is utilized in decisions for many federal courts, they want to know what was the spirit of the legislator. What did they mean for this to mean? Instead of doing that, he goes into this very defined approach and then says it will, the other part, the sex discrimination will survive this stage of the case, but really only because the school did not provide the reason for the difference between male and female students and their ability to wear long hair and the other not. So he gave them what they have to file in order to get these dismissed as well. I hope you see the picture. Okay? The fix is in. At this point, the Department of Justice is simply going to have to get involved. I hope the ACLU is watching. Barbers Hill Independent School District is led by this clown. There he is, the guy that decided to make an entire federal case literally over one student's ability to be expressive with an appropriate hairstyle inside of the school system. Greg Poole is his name. He said in a statement Wednesday, the decision to dismiss the racial claim, quote, validates what our district has maintained throughout this ordeal. High expectation for all students, all things are not racist. That's not what the judge said either, sir. I want to remind you, hairstyle is not a high expectation. It is an expression of culture. Having character like this young man has is high expectation. You, sir, are low expectation. All right, we'll bring you updates as they come.